Good afternoon, everyone. Welcome to the 9th meeting of the House State Government Committee. I now call this meeting to order. Before we call the roll, I'm going to ask everyone to please stand and pledge allegiance to the flag behind me, if you don't mind. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. You may be seated. Madam Secretary, please call the roll today, if you don't mind, please.
Representative Bojanowski.
Here.
Representative Bowling.
Here.
Representative Bratcher.
Here.
Representative Chester Burton. Here. Representative Graham. Here. Representative Heath. Representative Heverin. Representative Herron.
Here.
Representative Hodgson. Here. Representative Huff.
Here.
Representative Johnson.
Here.
Representative Maddox. Representative Rawlings.
Here.
Representative Tate. Here. Representative Tipton.
Here.
Representative Williams. Here. Representative Witten.
Here.
Representative Imes. Representative Hale.
Here. We do have a quorum today, and we are constituted to do business. Before we proceed to the first item on our agenda today, and we do have a very lengthy agenda today with 7 bills, I would remind everyone, please, in the audience, please silence your cell phones during the meeting at this time, if you don't mind. For those that will be coming to the table to speak, when you come to speak at the table, please make sure that your green light is on your microphone. And if you need to cast a vote, please make sure that you cast that loud enough so our secretary and we can record that. Again, welcome today. The first item on the agenda today is House Bill 517, sponsored by Representative Meade, an act relating to legislative ethics. Welcome, Representative Meade today. There is a proposed committee substitute. Is there a motion to the committee sub? There is a motion and there is a second. Before voting, Representative Bojanowski has a question concerning the sub.
Yes, sir. Could you please explain what's in the sub?
Yes. You got the sub before you now?
We have the
All
sub,
right.
yes.
I will explain. First of all, for the record.
You go ahead and explain the sub, and then we'll do the voice vote.
Okay, sounds good. For the record, I am David Meade, Speaker Pro Tem of the House, and I have with me today Eric Lykin, who's the General Counsel for the Speaker's Office. So what the sub does now actually is when a legislator makes a request for an advisory opinion to the commission will give a draft of the response. Then the person making that request may, if they choose, go before the commission to advocate for or against that opinion. That's how we, many times, legislators will submit to the commission to give us an opinion on something prior to us going on a trip, whatever it may be. That pertains to that. After the filing of a complaint on a elected official and the response time has ended for them to come back to the commission with their answer, the commission may dismiss the claim out of hand, as they sometimes do now. However, if it is not dismissed, the complaint must be brought before the entire commission, where they will vote to allow or dismiss the complaint. 5 commissioners must vote affirmatively in order to let the complaint continue on. It clarifies that an elected official, an officer of a federal, state agency, government employee, employees of state colleges, universities, or political subdivision operating in their fiduciary duty is not a legislative agent. It also clarifies that lobbying does not include a person whose official responsibilities do not include lobbying, is not compensated specifically for the purpose of lobbying, who is an officer, managerial personnel, or an employee with specialized knowledge or expertise of a business, and who participates in meetings or conversations accompanying a legislative agent engaged by the employer or organization to lobby on a particular issue. And then the last thing that it does is clarifies that a legislator can represent a client on licensing and permitting matters relating to the defense of pre-existing licensing and permits.
So that is a proposed committee sub. We do have a motion and a second on the committee sub. All in favor, say aye. Aye. Any opposed, same sign. The committee sub passes. Representative Meade, would you like to proceed with any further comments?
I think that's pretty much it.
Second.
We do have a motion on the bill and a second, but before we do the vote, we do have someone that is signed up to speak in opposition to the bill. Would Miss Laura Hendricks please come at this time? Miss Hendricks.
Okay. Sorry.
Good afternoon, ladies. Would
afternoon.
you both please identify yourself for the record today, and then you may proceed.
Yes, sir. I'm Laura Hendricks. I'm the Executive Director of the Legislative Ethics Commission.
Hi, I'm Emily Dennis. I'm the counsel for the Legislative Ethics Commission.
Thank you, ladies. The floor is yours. You may proceed.
Thank you. We appreciate you all letting us be here, Chairman Hale, for allowing us to comment on House Bill 517. And we also appreciate the sponsor for giving us a copy of the sub, which was very helpful to us. I just want to give you a little bit of background. I know you're busy, but just give you some background on what the ethics code, legislative ethics code, has meant to you all, and then lead into why it is that we have a few objections to how this bill is drafted. Just as background, 30 years ago, this General Assembly passed one of the strongest ethics code in the nation in response to the Bobtrot scandal, which has really helped protect the integrity of you all and the body. As a result, during the past 30 years, and I know you've heard me say this and my predecessors, unlike so many other states, as we point out in our monthly ethics reporter, no sitting Kentucky legislator has been convicted of a felony related to their legislative office, which is significant, and it's due to the General Assembly passing this law and strengthening the law. It ensures that legislators like yourselves and lobbyists stay far afield of the quid pro quo situations that arose prior to the law. People can file complaints, and they're rigorously examined by the commission. The public is able to comment and to interact with the commission. And as the Speaker Pro Tem said, we offer opinions all the time, mostly informal staff opinions, but as covered in his bill, also formal opinions by the commission. And also, we've always enjoyed a wonderful dialogue with legislators, lobbying groups, and the public. And the commission usually advises, and actually the commission is required by the law to propose additional legislation to affect the code. Now, I will say, of course, the General Assembly, you all make policy, but I will say these were not some of the recommendations made by the commission. But again, you all make the rules. But the way the process is set up, again, the complaint process as it exists now, the formal and informal opinion processes, required trainings of legislators, which you all attend and which new legislators attend every year, work to ensure, all these things work to ensure, and of course your all's commitment to that, work to ensure that legislative ethics is, your system is one of the strongest in the nation, and that ethics violations do not occur in the first place. And again, you all are the policymakers, and we stand ready to implement whatever policy you pass. However, since we do work with us on a daily basis, we do feel obligated to let you know that the change, as it's in the sub to the complaint process, would delay the commission's ability to find some of those essential facts surrounding complaints and elongate the process by creating an additional hurdle or an additional step towards beginning an investigation. Statistics, I'm a lawyer, I don't usually like math, but I think it's helpful to know that 132 formal complaints have been filed with the commission during its 30-year existence since 1993, after Bobtrot. Now, fully 2/3 of those, 88, have been dismissed by the commission on their face or after careful investigation, and by finding facts that don't lead to an ethics problem. Only 13 of these complaints, again, because we focus our efforts, as you all have wanted us to, on prevention, giving advice, only 13 of these complaints have resulted in a public violation, a public finding of a violation by either a legislator or a candidate. Again, our primary mission in the statutes is education and prevention. And your policies, the General Assembly's policies, have worked greatly to ensure that ethics is maintained compared to the scandals that we've seen in other states, many touching our borders, many very close to us. So, turning to the bill, and I appreciate
Ms.
the time.
Hendricks, I need you to please
Yeah.
in 2 minutes. If
Okay,
you could finish
okay.
this in 2
This-
minutes. We are very full
Got
on
it.
our agenda today.
Under the current law, we have to start a confidential preliminary inquiry after that sworn complaint is filed. And many times immediately, without waiting for the answer, what we're able to do is give that to our investigator, and they can start that process of the preliminary investigation, which quickly finds facts that allow that case to be dismissed. But under the substitute, the preliminary inquiry would not be allowed to go forward unless the commission meets in its next meeting to start that process. So, in other words, it would lengthen the time that the cases remain pending. And it wouldn't appear to shorten any case that was complex or complicated, because we do have those ones that are complicated and complex both in the facts and the law. Also, the new standard, which is reason to believe that the person named in the complaint has committed or is about to commit a violation of the code, which the commission would have to vote to find before that preliminary inquiry is done, seems to be a more subjective standard, and they won't have, the commission, the 9-member bipartisan commission, won't have the opportunity to know any facts to make that determination. The other thing in the sub that we'd like to address briefly is that the new provision would change the current requirement that a person who is paid by a company and is communicating to legislators about issues of interest to that company must register now as a legislative agent. But the sub would change that and say, well, if they have a legislative agent already engaged, then they wouldn't have to file themselves as a legislative agent. Again, that may reduce public transparency about who's communicating with legislators about those legislative interests, and again, it would be a change to the law as it stands. Again, based on our experience, these two parts might increase public criticism of the legislature or the Ethics Commission for adding those steps to the ethics complaint process, and perhaps decreasing the transparency in lobbying. And again, the commission is always happy to work with any member or groups of members to study and consider this as part of their normal yearly recommendations. And again, it just might have unintended consequences as we aren't aware of right now.
Thank you, Ms.
So I
Hendricks.
appreciate your time.
And since some of the statements that you made there, and again, not criticizing the statements, but I do think I need to allow Representative Meade to come back to the table and respond. And if you both want to stay there, you can.
Okay.
And Representative Meade, if you don't mind.
I'd like to ask a point of order
Point-
question, if I could.
You may ask that, please.
Who is Laura lobbying for? Are you a lobbyist today? Who are
No,
you?
sir.
Who are you speaking for?
Representative Bratcher, please address your question to Ms. Hendricks, if you don't
Who
mind.
are you working for today? Whose
I'm the
opinion is this right now?
I'm the executive director of the Legislative Ethics Commission, and as with any bill affecting the commission, we always come in and let you know how this would change our law. And of course, you all are the policymakers, and you can either change
That's
it or
right.
not.
We are the policymakers, and I don't understand who you're standing for right now. Are you a citizen of Kentucky? Is it your position? Is it the board that you work for? Is it the chairman? Who are you working for
Well,
right now?
the chairman asked us to look at this bill and see if it would have any effects on the code as we have it right now, and to give our views on that.
Well, your views are that you don't like the bill, right?
I think it has some issues, as I said, but I feel like you all, as policymakers, it would seem like it would be helpful to know what the past has been with respect to these provisions, and then what it may do in the future.
Well, I appreciate the history lesson, but more
Excuse
question.
me, please. If you could, please direct the questions through the chair. I am going to give Representative Meade an opportunity to respond to the statements that Ms. Hendricks made. Representative Meade, please proceed, please.
I'm gonna address just a couple things, and I'll turn it over to Eric to address a few more of them. But first, when we're talking about this process, they can still dismiss the claims the same as they have in the past. The only difference now is that if they decide that there is something there and that complaint is going forward, now instead of one unilateral decision being made of it going forward, it is more transparent by having all the commissioners' eyes on that complaint. That's the first thing. The second thing is the clarifying who a legislative agent is. I'll give you an example of what has happened to someone in my district who own a business, but they were advocating actually on some bills that were not, it had nothing to do with their business. They just were advocating for certain things like school choice, various bills that they were advocating for. They got an opinion that was sent to me that said that because they are speaking to me as my constituents on some of these issues, but it appeared that they were lobbying for some bills, trying to help push them along. They were giving me their opinion that they wanted to see them and be heard. Because of that, they had to register as legislative agent. That was the opinion. They ended up having to hire a lobbyist to come up here to talk to me about some of these issues. So that's one reason that we're clarifying things. But I'll turn this over to Eric so he can address some of the other issues.
So, Mr. Lacken, I don't know if you identified yourself earlier or not, did you?
I did not.
Please identify yourself for the record,
My name
please.
is Eric Lacken. I'm General Counsel for the House Majority.
Yes, sir.
And
Go ahead,
I
please.
want to understand, everybody understand, this is a process bill that's designed to give one more insulating layer of protection for legislators against the increasing lawfare that we're seeing with complaints being filed and attacks in the courts on public servants. So what we did is we based this off the Federal Election Commission process, which requires the commissioners to get involved up front. So you don't have an investigation that goes on for months and months and can potentially cost you, tens of thousands of dollars in legal fees for a job that pays just a few tens of thousands of dollars in legal fees. So it's one more layer of protection, and it also changes the advisory opinion process a little bit to also be more reflective of the FEC process. So it's a little bit more of a dialogue that if you can come to the commissioners and explain your argument straight to the commissioners. So that's what it does. It's a process. It doesn't change the no cup of coffee rule. It doesn't weaken the ethics law at all. It's just a process bill.
Representative Graham, you had a question.
To want to make a statement. I've been serving in General Assembly for 22 years, and in that time, Ms. Hendricks, she was working with LRC at one point in time. Matter of fact, for the majority party at one point, who were in the minority at the time in the House. But my question, my really statement is that you're doing your job, and what you're doing is telling us that what we have right now, we're considered to be one of the best in terms of the ethics system that we have in place. And because of what we have now, we've had very little problems in terms of members, because you educate us when we get here initially, and then we have those every year. We go through the process of what we can do and cannot do. And I've had to rely on you all on several things to make sure that I was going in the right direction. My question is, if it's that old saying, if it ain't broke, don't fix it. And we've been good about being considered one of the best ethics system in place for the General Assembly. And that's my concern. And I'm sorry that what was said earlier, I feel like it was inappropriate, because you have the responsibility that's been given to you by your commission to come forth, which you were asked to do, and you followed up with what was requested by your commission. So from me, I apologize for what you've had to go through. Not that I have done it, but the fact of the matter, we are all part of this body of the House of Representatives. And just to let you know that we support what you all have done over the years that you've been in existence, and how it has helped us as members of the General Assembly. Thank you, Mr.
Representative Bratcher has a follow-up question. Quickly, Representative Bratcher.
Yeah,
if you don't mind.
I apologize that my colleague doesn't understand what my question was. And my question is, who are you speaking for the entire board there? Did they tell you to come here today and
Well,
oppose
actually,
this bill?
As I said, normally the commission process would be to put out their ideas for changes to the code, and actually we always send those to all the legislators, right, through the LRC. Since we weren't made aware of the fact that this bill was going to come up until today, but graciously they also let us know about the sub and gave us that, which did.
So
make
you're not
sense.
speaking for the entire board?
Do you want me to finish?
Yeah, I want you to answer yes or no. Are you speaking
Please,
for the
please
entire
give her
board?
time to finish her statement.
So they will have a meeting on Monday, and at that time, they may vote to say, well, yeah, we support it or we don't. But in my discussions with the chairperson of the committee, who's Dave Nicholas, who was a former staff member here for a long time, you may know Dave. The usual process would be for us to come in as staff and just point out if there are issues with the bill. And it's certainly not personal to
Well,
Representative Meade
one more.
or to anyone else. That's also how the process works. And I apologize if that's offensive to anyone. I will say too, I wasn't only a partisan. I've spent most of my life as a nonpartisan staff person for LRC. That was as the general counsel for LRC.
One more follow-up question.
Okay.
This will be the
Yeah.
last question, then we're going to vote.
A short comment and a question. I have no problem with the way you've operated that office. I think I've known you for a long time, and I know that you're a great public employee. And my only question is, why are you here fighting this on your own without your commission support? And are you willing to get behind this bill? Can you follow this bill if it passes? Are you going to
Well,
work
I
in
believe
good diligence with it?
Sure, and that's what I think I said, and I apologize if I didn't say it as strongly as I should have, maybe. But you all make the policy. I'm merely pointing out the policy or the law. It's not the policy; it's the law. The laws that exist now and how that would change, and potentially how we think that could change our process, and that it would lengthen it somehow. Again. Would it be a terrible, awful thing? No. But if I thought it, I feel like I'm doing you all a disservice not to tell you.
Representative Meade, you have the last word.
Anyway.
Anything you'd like to add, and then
Thank you, Mr. Chairman. Well, first of all, I'll say that I don't doubt Ms. Hendricks' professionalism in any way. I think that she will, if this passes, she will completely follow it to the T. I want to say that. But I will also, just to comment back to Representative Graham about if it's not broke, don't fix it. That's the problem, is this process is broken. We'll give you an example. One of our colleagues just went through this process, and because of a single decision made for this complaint to go on, it cost her $30,000 in attorney fees to defend herself for an unfounded and unbiased claim. And that was what the result was. Had this have gone before the commission prior to that, they would have found that out. It would have saved her a whole lot of heartache, time, and money.
Thank you, ladies. I need you all to step away from the table if you don't mind at this time. We do have a motion by Representative Johnson, a second by Representative Williams. Madam Secretary, please call the roll.
Representative Bojanowski,
Pass.
Representative Bowling. Yes. Representative Bratcher.
Yes.
Representative Chester Burton.
No.
Representative Graham.
Explain my vote.
Yes, sir. Quickly.
Yes, and I understand that you were dealing with a constituent, but that's one out of the many hundreds or thousands that have come through that the organization has been able to help us get through it. And I still believe that it is still the strongest, is one of the strongest, and we should keep it intact because we're nationally known with it. And because of that, I'm voting no. Thank you.
Representative Heath.
Yes.
Representative Heverin.
Yes.
Representative Herron.
Pass.
Representative Hodgson. Representative Huff.
Yes.
Representative Imes.
Yes.
Representative Johnson?
Yes.
Representative Maddox?
Yes.
Representative Rawlings?
Yes.
Representative Tate?
Yes.
Representative Tipton?
Yes.
Representative Williams? Representative Witten? Representative Hale?
Yes. House Bill 517 passes with 14 yes votes, 2 no votes, and 2 pass votes. Passes with favorable expressions. Should do the same on the House floor. Thank you, gentlemen, very much. Appreciate it today.
Thank you, Mr. Chairman and members of the committee.
The next item on our agenda today is Senate Bill 17, sponsored by Senator Deneen, an act relating to certificates of death. Senator Deneen, would you please come to the table, and anyone that may be with you? And I might add, this is the first senator that's appeared before this committee this year, so you get to be you get to be first on the list. I'm sure you won't be the last, but please introduce yourself, please, and the other gentleman, and for the record, and then you may proceed.
My name is Matt Deneen. I am the senator for the 10th District.
Pat Elmore, Hardin
Push
County
your button there, Max.
Pat Elmore, Hardin County Coroner.
Dr. Bill Lee, retired Hardin County Coroner, past 31 years.
Thank you, gentlemen. Senator, the floor is yours. You may proceed.
Thank you, Mr. Chairman and committee members. Senate Bill 17 really is a bill that addresses the modernization of the reality that our coroners are dealing with. Under current statute, they have 5 days to award a death certificate. But as we all know, when there are toxicology reports and dealing with overdoses or autopsy reports or ballistics reports that have to be done, it's not realistic to think that they can get all of that done within a 5-day period and award a death certificate that is appropriate. Currently, they are forced to, within 5 days, fill out a death certificate, award it with an unknown cause, only to follow up in 3 weeks after all these studies are done and to do the same thing all over again for no benefit other than red tape. There is no financial benefit for any of the victims.
There is a motion on the bill, and there is a second. Would you like to proceed any further? Or are you
No,
ready?
sir.
All right. Thank you, sir. There has been a motion made and a second. We do have a question. Representative Maddox.
Thank you, Senator. I just am curious about, just looking through this, I had hoped that you would be able to explain it. Sure. Maybe I could spare you my questions. But when the medical certification is completed, are they going to come back? I mean, is it going to be clarified, the cause of death at a later point? Okay.
Absolutely. They have 5 days once the toxicology reports and the ballistics test and all those tests are done. The coroner has 5 days to award that death certificate upon the conclusion of those studies.
Okay, I just wanted to know how it worked. Thank
Absolutely.
you, sir.
Any other? Yes, Representative Graham. Go ahead, sir.
Will this make it a little bit longer for the death certificates to be received?
Only in cases that would require such studies to be done. For the vast majority of deaths, it would not, sir.
Okay, thank you.
Seeing no further questions or comments, Madam Secretary, please call the roll.
Representative Bojanowski?
Yes.
Representative Bowling? Yes. Representative Bratcher?
Yes.
Representative Chester Burton?
Yes.
Representative Graham?
Yes.
Representative Heath?
Yes.
Representative Heverin? Yes. Representative Herron?
Yes.
Representative Hodgson? Yes. Representative Huff?
Yes.
Representative Imes?
Yes.
Representative Johnson?
Yes.
Representative Maddox?
Yes.
Representative Rawlings?
Yes.
Representative Tate?
Yes.
Representative Tipton?
Yes.
Representative Williams?
Yes.
Representative Witten? Representative Hale?
Yes. Senate Bill 17 passes with 18 favorable votes, 0 no votes. Should pass with favorable expression as the same on the House floor. Thank you, Senator, for being with us today, and your guests. Thank you very much.
Thank you, Mr. Chairman. Thank you, committee members.
The next item on our agenda today is House Bill 214, sponsored by Representative Hart. House Bill 214 is an act relating to individuals with intellectual and developmental disabilities. Representative Hart, would you please come to the table at this time? And if there's someone going to join you, come right on up to the table, folks. We're glad to have you and we welcome you today.
Thank you, Mr. Chairman.
Please introduce yourself, Representative Hart, for the record.
And I'm going to go ahead and introduce my two guests as well.
You may do that as well.
To my direct right is Mr. Frankie Huffman. He is a disability rights advocate from Pendleton County. And to his right is Mr. Arthur Campbell Jr. He is a nationally recognized disability rights advocate, and he is from Louisville, Kentucky.
And if we don't mind, is the lady going to speak?
She is going to read a statement that Mr. Campbell has prepared.
Would you introduce yourself, ma'am, for the record, please?
Yes, my name is Anita, and I work for Mr. Wolf.
Thank you very much. We welcome you to our committee today. Thank you. Representative Hart, the floor is yours.
Thank you, Mr. Chairman. House Bill 214 clarifies the rights of individuals with intellectual and developmental disabilities. There's two sections of the bill. Section 1 of this bill creates a new section of KRS Chapter 210 to define terms, state legislative findings for the rights of individuals with intellectual and developmental disabilities. And Section 2 establishes a cause of action to the Attorney General and permits the Attorney General to initiate a civil action, and it also sets the parameters for the circuit courts to follow. That's all the bill does. And at this time, I'd like to turn it over to Mr. Huffman for a statement.
This bill is important to me because right now the way the law states, I'll give you an example. Like let's say I wanted to get like a job in the community or have a relationship with somebody, or even just like a friend. A lot of people in my situation that had guardians, they had to ask permission to their parents to be able to do things like that. And I think as an individual, we should have the right to make those decisions.
Thank you very much, sir, for that statement. We appreciate you being with us. Madam, would you please like to read your statement for the record? You may proceed. Pull the microphone close to you, and you may read that for the record.
Okay. I want to thank the committee and the representative, Mark Hart, for permitting my associate and me to speak briefly on House Bill 214, as known as Frank Huffman Act. Before I speak about House Bill 214, I would like to introduce myself. I am Walter Campbell Jr. I am a person with multiple and severe disabilities with a severe speech impairment. I cannot speak clearly enough so that most people can understand my words. So I will have an interpreter assistant when I'm speaking with you. I am disability activist and a civil rights worker, working to empower and improve the lives of my brothers and sisters with disabilities with dignity. I have been involved in this work for 40 years. In fact, I have dedicated the rest of my life to this work of empowering my brothers and sisters with both mentally and physically disability. If you want to know more about my life, there's a link. There's gonna be papers passed around if anybody wanna go and watch. The Frank Hoffman Act will enhance and expand the current Bill of Rights 337 and it considers a person's right in all aspects of life, including medical, personal, and living arrangement, family, and others. Allows a person with IDD or someone on the person's behalf to file a notice of violation with the Attorney General, who decides if there's an ingressions or flagrant violation of one of the rights, which equals a pattern of practice. If so, the Attorney General can file a civil action in court. If the court decides there is a violation, it can stop the practice and award money. Again, I want to thank the committee and Representative Mark Hart for permitting my associate and me to speak briefly on Representative Mark Hart, House Bill 214, known as Frank Hoffman Act. House Bill 214 will greatly improve the lives of my dear brothers and sisters with intellectual and physical disability. Thank you for letting me speak on behalf of my brothers and sisters. Thank you for listening to me despite my speaking abilities.
Mr. Chairman, if there's any other questions.
Thank you very much, ma'am. We appreciate your time. We do have a question from Representative Bojanowski.
All right, so not a question, more of a statement. Representative Hart, I thank you for bringing this legislation. I have an adult son with a developmental disability, and I'm a special ed teacher. And so I fiercely advocate for not only my son, but also my students. And I think that your bill will help us to do that. So I'm greatly appreciative. Thank you.
Thank you, Representative.
Is there a motion on House Bill 214? There is a motion by Representative Tate, a second by Representative Hodgson. Any other comments or questions? Seeing none, Madam Secretary, please call the roll.
Representative Bojanowski?
Yes.
Representative Bowling? Yes. Representative Bratcher?
Yes.
Representative Chester Burton?
Yes.
Representative Graham?
Yes.
Representative Heath?
Yes.
Representative Heverin? Representative Herron?
Yes.
Representative Hodgson? Yes. Representative Huff?
Yes.
Representative Imes?
Yes.
Representative Johnson?
Yes.
Representative Maddox?
Yes.
Representative Rawlings?
Yes.
Representative Tate?
Yes.
Representative Tipton?
Yes.
Representative Williams?
Yes.
Representative Witten? Representative Hale?
Yes. House Bill 214 passes with 18 yea votes, 0 nay votes. Should do the same on the House floor. Thank you all very much for being with us today. Appreciate your time.
Thank you,
and
Mr.
your
Chairman,
guests.
and members of the committee.
Thank you.
Mr. Chairman, may I ask a question, please?
Yes, ma'am.
I apologize, but according to our rules, do we have the opportunity to add a bill to?
We don't have it.
Representative Tate, I actually didn't hear your question clear. If you could speak.
According to the rules, do we have the opportunity to add a bill to the consent calendar?
No. No, ma'am.
Okay, thank you.
The next item on our agenda today is House Bill 509, sponsored by Representative Hodgson. Representative Hodgson, as you are coming to the table, There is a proposed committee substitute to House Bill 509. Is there a motion for the committee substitute?
Motion on the sub.
There is a motion. Is there a second? We do have a motion and a second. Representative Bojanowski has a question concerning
Yes,
the
sir.
committee sub. Representative
Right.
Bojanowski.
Could you explain the difference between the original bill and the sub, please?
Yes, the original bill made some alterations to KRS 61.870 and 61.878, and those two sections have been removed in their entirety.
Representative Hodgson, please identify yourself for the record, and then I'm sorry, we do need a voice vote to accept the committee substitute. All in favor say aye. Aye. All opposed? Motion carries. Representative Hodgson, please introduce yourself and the floor is yours.
Thank you, Mr. Chairman. John Hodgson, State Representative, District 36. Kentucky's open record statutes that start in KRS 61.870 have been around since the 70s and are really an excellent product and have yielded good results over the years. However, no one in the 1970s envisioned email, text messages, and the like that have come to dominate a lot of our communication. And as such, we're trying to modernize the language here and anticipate where things may go with open record requests. So what this bill does is three things. First, it says that anyone who is working for a public agency or is a board appointee, even an unpaid board member of a county board, fair board, park commission, tree commission, anything like that, would have created for them an official email account to do their official agency business. That's not always been the case in the past, causing people to use their own devices, their own email accounts to conduct official business. We want to clarify that. Worked with members of KCO and KLC to make sure they could implement this policy as well as state government, and we're good there. So we will get every official an email account that is for their public business. Secondly, having done that, members of public agencies and board members who conduct their official business on other accounts, personal accounts, would be liable to discipline from their agency or dismissal if they are board members to ensure we have compliance. And then finally, for agencies that are in compliance with this policy, they would not be required to search for or produce to a requesting party electronic information or documents that are not stored in a device that's the property of the public agency or an email account that is not an agency-furnished email. So that's the crux of the bill. It's consistent with the federal FOIA statute and kind of sets the, with some pending court cases and things like that, sets the stage going forward for what is appropriate for those open record searches and what is not.
Before we go to questions, we do have someone that is signed up to speak about this specific bill, Mr. Michael Abate. Am I pronouncing that correct, sir?
It's Michael Abate.
Abate. I apologize, sir. My apologies. Mr. Abate, please identify yourself for the record, and then you may proceed and push the button. Yes, sir. Thank you.
Thank you, Mr. Chairman. My name is Michael Abate. I'm an attorney at the firm of Kaplan Johnson Abate and Bird in Louisville. I also serve as general counsel to the Kentucky Press Association, and that's why I'm here today. I do want to thank the sponsor for making some changes to the original bill in the committee sub. We think those are productive changes. We had some criticisms of the sweep of the original bill. So, I'm here to say we think this is moving in the right direction. I think the first 2 points Representative Hodgson laid out are great points. We have a concern about the third point, and I just want to put some meat on the bones and explain why we think there's still a loophole in this bill that needs to be plugged, and we would be happy to work with the committee, with the sponsor to try to plug it. But let me give you an example. We have a number of member organizations who've tried to get information out of JCPS about what happened during the epic meltdown of busing in the first few days of the school year. We requested emails on all records, and they came back and told us, oh, we only have like 2 emails because the superintendent and the transportation director and everybody else has been texting throughout this whole thing. Well, we want to know what they were texting about. We want to know what was happening. We want to know what's going on. JCPS has taken the position those aren't public records. That's contrary to court cases. We can deal with that. But under this bill, we would not have the right to see what employees were texting each other during the JCPS meltdown. We think that's a loophole that can be and should be plugged. We have a couple specific suggestions. I think it's laudable that this bill says if you have a public email account, you shouldn't privately email. However, it doesn't say you shouldn't text on a private device about public business, even though it then turns around and exempts the agency from doing so, from searching for those records. So we think that's a loophole. Another loophole that we think should be plugged is for employees, as opposed to, say, commission members who themselves are already public agencies subject to the act. We think there's a problem. If you intentionally violate this and conduct business on your personal device, your personal email account, you can be subject to discipline, but we also think that it should be very clear that that person could also receive an open records request for the records they create in violation of state law. Right now, that's not 100% clear because you have to serve a request on the custodian, and this bill would say that the custodian doesn't have to go search for that if it's, say, the superintendent or the transportation director, and so the public would be left in the dark. I think that example is a clear one. The citizens and taxpayers and parents of Jefferson County have the right to know what was going on within their school district as transportation was melting down around them. And we just think there are a few tweaks to this bill that can and should be made to help make sure we don't, frankly, create a giant loophole through which somebody who was determined to hide their communications could easily just walk through text or email in violation of the statute and say, haha, that's not subject to open records anymore. Nobody can see that. So we're grateful for the changes that have been made. We'd like to see further changes made. And, for that reason, we can't support the bill as is, but we'd be happy to work to get it somewhere
if
we
you'll
could.
just remain at the table, Mr. Abadi. Representative Hodgson, do you have a response?
I do. I understand what the gentleman's saying here. In addition to being an advocate for open records, I am also an advocate for personal privacy. And I think we've got a huge fault line approaching here between the intersection of those 2 points. Because you don't just have a personal phone with text message capability. You've got personal email. You've got direct message on Facebook, direct message on Twitter, direct message on Nextdoor. And you could be in a situation where you'd walk in as an employee or as a board member of one of these organizations, and the open records coordinator says, I need you to hand me your phone today and all your social media passwords, your text messages, and your email passwords for this open-ended fishing expedition that could be launched by any of 4 million Kentuckians. And I think that crosses a line for an individual if there's no evidence that they've had some wrongdoing. It's somebody just saying, I want to look to see maybe if there was something here. I think the example he mentioned about the little bus meltdown was absolutely horrible. But I would refer you to KRS 61.878 that says right now, records in the list of records that are exempt from disclosure include preliminary drafts, notes, correspondence with private individuals, preliminary recommendations, preliminary memoranda, opinions expressed, policies formulated, or recommendations. So right now, under KRS 878, an agency could say we are not disclosing these records due to these exemptions, and that those exemptions would certainly apply to a person's personal cell phone. If there's some evidence of wrongdoing that you can convince a court, we certainly have the opportunity to go file civil or criminal charges and have a subpoena and access those records. But I think to subject probably almost 500,000 people in this state that either work for a public agency or are unpaid board volunteers to this kind of scrutiny in their personal life is crossing the line. And again, this is consistent with federal FOIA, Freedom of Information Act regulations.
Mr. Abadi, you've given me a signal you'd like to respond. You have 30 seconds, sir. We do have questions that we need
of
to.
Course.
We have questions from some of the members, so please go.
Of course, Mr. Chairman. I just want to be clear because we litigate these cases all the time. No one ever thinks that somebody's going to hand over their phone to be forensically examined. Our point is just this. If you choose to create a public record on a personal device, you run the risk that if somebody asks you, you're going to have to screenshot the text and hand it over. That's it. No one's asking for intrusive searches of somebody's devices. And also, I do litigate these cases. Text messages among public employees are not preliminary drafts that can be withheld forever. We've litigated that many, many times. I understand the concerns, and I think we can work through them, but the answer can't be no text messages ever available or no personal emails ever available, because that's the only thing people will choose to communicate, and the public will pay the price for that.
Representative Bojanowski, you have a question.
Yes. Representative, could you speak on the Court of Appeals and Kentucky Open Government Coalition versus Kentucky Wildlife Resources, where the opinion held that text messages related to commission business and stored on personal cell phones of its members are public records, generally subject to disclosure under the Open Records Act, absent an applicable exception?
Yes, I think this is a case that prompted this bill because it was an area that had not been discussed a lot in case law before. In this case, I don't know that the commission members did have an official email available to them. In the condition that if the possibility that they did not, might have suggested they use their personal device for some communications. So this is an attempt to clarify it, to modernize it. You know, when this open records law was passed in the 1970s, people had verbal conversations that, of course, were not disclosable. They had telephone conversations that were not disclosable. They might have had, you know, scrap of paper that they threw away in the trash can that was not disclosable. Those have been supplanted in our modern era by text messages and emails. And I think we've got to have an environment where people can have a discussion, ask a question, say, hey, what time is the committee meeting, without everything being laid bare and subject to a search. Because the fact of the matter is, the search itself is a very punitive action. We spend tens of millions of dollars in agencies every year doing open records requests. Some of them are by individuals that have a personal or political motive and do these things to shut down the effectiveness of these agencies. I think we've got to put some limitations on it. The public absolutely has a right to know. I was a citizen activist for 15 years. I made use of the open records rules myself, but I'm also an electronic privacy advocate, as you know. So like I say, we're on the fault line between those issues right here, and I think this bill strikes an appropriate balance.
May I speak very briefly?
Yes, ma'am.
Okay, so, I mean, I think ultimately it'll result in more public employees and officials or private devices because there wouldn't be any mechanism for exposing it in an open records request. A public record is a public record regardless of where it's stored. But this bill proceeds from the false belief that public business is not the public's business if it is conducted on a private device or account.
We do have one more question, but before I go to that question, I just wanted to let all the members be aware. I was contacted last night by the Kentucky Open Government Coalition, which actually opposed House Bill 509, and there was a letter that should be in everyone's packet today, and I just wanted to make record that that letter was placed in each of your packets. The next question is Representative Tipton.
Thank you, Mr. Chair. And just for clarification, I have two quick questions. First, somebody uses their personal device, laptop, phone, and they use an official email account. That email account is still subject to open records, correct?
Yes.
Second question, if I may follow up, Mr. Chair.
Yes, go ahead, please.
Some agencies, individuals, employees are given work phones to use. Is there anything in this bill that addresses if somebody has a work phone and the ability that's exclusively for their work business, for the open records, text messages and things would be subject to open records in that regard?
Yes, if your agency issues a device, which a lot of people in the executive branch has, that device is under the full scrutiny of that agency. And in fact, the COT has a method to go do global searches through everybody's email for certain keywords. And I think as we move into the future, these searches will become more and more automated and automatic because it takes thousands of hours to do open records research. But yeah, I mean, both in my corporate life and in my time that I spent in the executive branch, I always had a personal phone and I had a company phone, if you will, knowing that try to keep the two separated to the greatest extent possible. And even so, I mean, you probably found this as a representative. I get contacted all manner of ways, and I want to funnel people towards my legislative email account because that's easier for me, and it's easier for me to respond that way. But
is there a motion on the bill? There is a motion by Representative Tate. There is a second by Representative Heath. Seeing no further discussion or questions, Madam Secretary, please call the roll.
Representative Bojanowski?
No.
Representative Bowling? Yes. Representative Bradsher?
Yes.
Representative Chester Burton?
No.
Representative Graham?
No.
Representative Heath?
Yes.
Representative Heverin? Yes. Representative Herron?
No.
Representative Hodgson?
yes.
Representative Huff?
Yes.
Representative Imes?
Yes.
Representative Johnson?
Yes.
Representative Maddox?
Pass.
Representative Rawlings?
Pass.
Representative Tate?
Yes.
Representative Tipton?
Yes.
Representative Williams?
Yes.
Representative Witten? Representative Hale?
Yes. House Bill 509 receiving 12 yes votes, 4 no votes, and 2 pass votes passes with favorable expression. Thank you, Representative, and thank you, sir, for being with us today.
Thank you, Mr. Chairman.
As we move to the next item on our agenda, we now go to House Bill 661, sponsored by Representative Blanton. Representative Blanton, would you please come to the table? And House Bill 661 is an act relating to pension spiking in the Kentucky Public Pension Authority. Welcome, Representative Blanton. Please introduce yourself for the record and your guest that's with you today. Have her introduce herself, and then you may.
Thank you, Mr. Chairman. John Blanton with the 92nd District, and I will let Erin introduce herself.
Good afternoon. I'm Erin Surratt. I am the Executive Director of the Office of Benefits at the Kentucky Public Pensions Authority.
Representative Blanton, the floor is yours.
Thank you, Mr. Chairman. This will be much more brief than the previous bills you've been hearing today. This simply codifies the language dealing with pension spiking from raises that's given to multiple employees at a time, that codifies the law with the language the courts have ruled. As an example, when we gave a recent pay raise to KSP for 15, that above the 10% spiking, and the courts have said that's not considered spiking because it was given to all of them. All this does is codify that court language for the pension authority.
There is a motion on the bill. No.
We're not calling the sub.
We are not calling the sub, ma'am. There is a motion on the bill. There is a second. Any discussion or question? Seeing none, Madam Secretary, please call the roll.
Representative Bojanowski,
Yes.
Representative Bowling,
Yes.
Representative Bratcher, Representative Chester Burton,
Yes.
Representative Graham,
Yes.
Representative Heath,
Yes.
Representative Heverin, Representative Herron,
Yes.
Representative Hodgson, Representative Huff,
Yes.
Representative Himes,
Yes.
Representative Johnson,
Yes.
Representative Maddox,
Yes.
Representative Rawlings,
Yes.
Representative Tate,
Yes.
Representative Tipton,
Yes.
Representative Williams,
Yes.
Representative Witten,
Yes.
Representative Hale.
Yes. House Bill 661 receiving 18 favorable votes, 0 votes against, passes with favorable expression, and should do the same on the House floor. Thank you very much, Representative
Mr.
Blanton.
Speaker, excuse me, Mr. Chairman, may I make a point of order, please?
Yes, ma'am, you may.
Okay, I'm looking at House Resolution Number 2, which was adopted on January 2nd of 2024, that says, according to Rule 57, there is a consent calendar allowed.
Committee will stand at ease.
Thank you. I don't know. That is Rule 57.
Representative Tate, your point of order is taken. As I read the rule, it does state that we may, at this particular time, I am not going to go down that road at the current time. I know the Senate has consent. Currently, the House, we do not generally permit that. We have in the past on certain times of the session, but at this time, this will remain off we will not put this on the consent calendar.
Mr. Chairman, may I make a question, make a statement, please, or a question, please?
Yes, ma'am.
Yes,
You may.
and we will pursue this further to make sure that this Rule 57 can be enacted. That's a question.
Yes, ma'am. I will pursue that. Yes.
Thank you, sir.
Thank you. Thank you, Representative Blanton.
Thank you, Mr. Chairman, members of the committee.
Representative Whitten, do you have a question?
I would just like to register my votes.
You may go ahead at
Now's
this
the
time.
right time?
You can do it right now while
Thank-
the next presenter is getting ready.
Thank you. For Senate Bill 17, I'm a yes. House Bill 214, I'm a yes. And House Bill 517, I'm a yes. Thank you, Mr. Chair.
The next item on the agenda at this time is House Bill 777. What a perfect number. Sponsored by Representative McPherson. House Bill 777 is an act relating to government contracts and declare an emergency. Representative McPherson, if you make your way to the table. There is I need a motion to adopt the proposed committee substitute to House Bill 777. There is a motion and there is a second. Representative Bojanowski has a question on the committee sub.
Yes,
Representative
sir.
Bojanowski.
Could you explain the difference between the committee sub and the original bill, please?
Yes, ma'am. The committee sub basically is a cleanup of a few words that were duplicated, but mainly on page 7, line 11, we had 30 days in there twice in the same line, and we removed the second 30 days to allow this to be contract negotiated.
We do have a motion and a second on the proposed committee sub. All in favor say aye. Aye. Any opposed? The committee sub is adopted. Representative McPherson, you may proceed on House Bill 777 as amended by the committee substitute.
Well, thank you, Mr. Chairman, and thank you, committee. My name's Sean McPherson. I represent the 22nd District. I will allow my guest to introduce
Please
herself.
do, ma'am.
My name is Danielle Clore.
Please punch the button until the green light is on.
My name is Danielle Clore, and I'm the CEO of Kentucky Nonprofit Network.
Thank you, Ms. Clore. Representative McPherson, proceed.
Yes, so thank you, committee, again. House Bill 777, and I did have 2 or 3 bills in my hand and chose House Bill number 777 for this bill. This attempts to streamline government contracts. It's trying to make the government more efficient. We have a lot of these statutes on record right now, but this bill would better give the framework for the state government to pay their bills. We have a lot of contracts out there right now, especially with grants and different things that we're going through. We've got House Bill 9 that was passed last year that we're going to pass a lot of money through in the next couple of years on grants and such. And we want these contracts to be fulfilled. We want them to be fulfilled in a timely manner. If somebody bids a contract, then they need to have the understanding that this contract will have the money and the teeth to it to pay the person that they're actually being bid. Let me give you an example of this summer. I was contacted by one of my constituents in my district that said they had a grant that had been hanging out there since 2019. I made numerous phone calls and never did receive a phone call back from anyone at the state level trying to understand why this grant wasn't being available at the time. It was an active grant. They had taken $5,000 out of it and paid some engineering fees. But I couldn't. I finally did get a letter back from somebody, and the constituents did get going forth down the line that they were then shown the activity of that contract and going forward. That contract was $200,000 that grant was $200,000 in 2019. The bid that came in 2024 was about $600,000. We are losing the ability to do the work that we're saying to do. If it's important enough to to give the grant, it's important enough to pay. And it's important enough to pay timely so that we can be efficient in asking our people to bid these, knowing that they'll be paid when they get finished.
Ma'am, would you like to add anything?
Yes, please. I appreciate the opportunity to speak with you all today, really with a nonprofit lens on this issue. A number of nonprofits partner with the Commonwealth to provide programs and services. Some of those are statutorily mandated or required services to your constituents, and late payments are threatening their work, unfortunately, and exacerbating a workforce shortage, prohibiting them from paying their for-profit vendors on time, and ultimately, it's the Kentuckians that receive services that are losing. This is not unique to this administration. It's not unique to Kentucky, unfortunately, but we're in a perfect storm of demand for services, declines in charitable giving, and workforce shortage. And so we've got to get folks paid on time. So we appreciate the opportunity to be able to put some of these teeth into some of these things so that nonprofits primarily know what their recourse is, that they know that they can recoup some of these late payments and interest on those payments. We have one of our members who's running cost to their organization of $75,000 so far this year on interest that they could pay staff with because of lines of credit that they've had to take out to float the state. We don't think that's a good use of a charity's funds.
There has been a motion and a second on the bill as amended by the committee sub. We do have a question. Representative Williams.
Thank you, Representative Pearson, for bringing this. My question is, does this only apply to contractual with nonprofits, or is it with regular contractors as well?
So it would be contractors anywhere in the state. I mean, so I had an example of, I have a sister-in-law that's a speech pathologist. The bill writer had a sister-in-law that once they contracted the state to do work sometimes also, and so it could be that they're having to be paid for 90 to 120 days. They're providing the service, and then this is here in statute, and it has a 12% penalty fee, 1% per month, but they have no real way to activate this and make them go forward and pay it. So again, this is just trying to put framework and teeth into saying, if you provide a service, you know when you'll get paid. And I will say that they can negotiate those terms. If they want to negotiate them, industry standards, that the Transportation Cabinet called me the other day and said, would this hurt us if we negotiate longer? Whatever you negotiate in memorandum is your choice. That's why we made the committee sub. We don't want to tie you to anything, but we do want to say whatever everybody agrees to, that's what we want to be paid, and that's a timely manner.
Well, I appreciate you bringing it. I had a constituent who was in the same boat. It was 4 months before he got paid. He had to go get a loan from the bank to pay his employees just to wait on the state to pay him. So I appreciate you bringing it. Thank you.
Seeing no further discussion or questions, we have a motion and a second as amended by the committee sub on House Bill 777. Madam Secretary, please call the roll.
Representative Bojanowski?
Yes.
Representative Bowling? Yes. Representative Bratcher?
Yes.
Representative Chester Burton?
Yes.
Representative Graham?
I hope, I'm voting yes on this, and I hope that the organizations within state government will try to work with those individuals who have received those particular dollars to make sure they're advocated out as soon as possible once the work has been done.
Thank you.
Thank you.
Representative Heath?
Yes.
Representative Heverin?
Yes.
Representative Herron?
Yes.
Representative Hodgson? Representative Huff?
Yes.
Representative Imes?
Yes.
Representative Johnson?
Yes.
Representative Maddox?
Yes.
Representative Rawlings?
Yes.
Representative Tate? Yes. Representative Tipton?
Yes.
Representative Williams?
Yes.
Representative Witten?
Yes.
Representative Hale?
Yes. House Bill 777 receiving 19 favorable votes, 0 votes against, passes with favorable expression and should do the same on the House floor. Thank you, Representative McPherson.
Thank you, Mr.
And
Chair.
your
and thank you,
guest is
committee.
with you today. Thank you
Yes.
very much. We move to the last item on our agenda today, House Bill 138, which is sponsored by Representative Grossberg. House Bill 138 is an act relating to service credit for the teachers' retirement system and declaring an emergency. Representative Grossberg, welcome to our State Government Committee today. At this time, I'm going to ask you to introduce yourself for the record and also your guest that is with you today for the record, and then you may proceed, please. Go ahead, sir.
Thank you, Representative Daniel Grossberg, 30th District out of Louisville.
I'm Eddie Campbell. I'm a Midland High School music teacher from Knox County, Kentucky, currently serving as president of the Kentucky Education Association.
Thank you, Mr. Campbell, for being with us today. Representative Grossberg, the floor is yours. You may proceed and explain to us House Bill 138.
Thank you. I know we are limited on time, so I will be as brief as possible. House Bill 138, which many of you in this room are already co-sponsors of, simply allows teachers to take off for religious observance and to make up those days of work for service credit. In the status quo, if a teacher is to take off for religious observance, their options are to call in sick, which is being dishonest and fraudulent, or to miss out on retirement credit. As a consequence, some teachers just don't observe their religion. This bill, for which I am grateful for the assistance of those on the committee, most notably Representative Tipton, who coached me through all of the pitfalls of writing a bill and getting everyone's approval, the makeup days must be for teacher-related duties, not for any and everything that you can do at the school. It must be a makeup day. You cannot bank days in advance to take off later for religious observance. It is a maximum of 10 days per year, and this bill would only codify these provisions going forward. It does not make up for teachers who unfortunately have lost due to religious observance in the past. Kentucky has a profound commitment to religious freedom, and it's one of the hallmarks of our state for which I am very grateful. This bill has broad bipartisan support. It is supported by the KEA and JCTA. It is supported by JCPS, school administrator associations. It is supported by literally every single rabbi and cantor in Kentucky, from whom you should have received a joint letter of the unanimous support, as well as other religious minorities. Many of you have asked me in other contexts, what can we do in Kentucky to fight back against anti-Semitism and other forms of religious intolerance? And this is one of those things. We can do a number of resolutions as we have in the past, but this is consequential. This bill is not a token bill. It says to every teacher and teacher spouse and everyone else paying attention that we embrace religious diversity and we embrace religious freedom and religious expression.
Motion on the bill.
There has been a motion and a second on the bill. Mr. Campbell, anything you'd like to add, sir?
No, just the KEA supports this bill, and we appreciate Representative Grossberg bringing the bill and the committee hearing it.
Thank you, sir. Is there any questions for Representative Grossberg? Representative Johnson, you may go ahead, sir.
Thank you, Mr. Chairman. Just to for the record and clarify, this does not add any additional days or anything like that. It's simply providing an opportunity to make up the days that you might miss for religious purposes, correct?
That is 100% correct. And to quote the actuarial impact statement, quote, there would be no change in benefit payments by TRS, unquote.
Thank you, Mr. Chairman.
Seeing no further questions, we do have a motion and a second on House Bill 138. Madam Secretary, please call the roll.
Representative Bojanowski?
Yes.
Representative Bowling?
Yes.
Representative Bratcher?
Yes.
Representative Chester Burton?
Yes.
Representative Graham?
Yes.
Representative Heath?
Yes.
Representative Hevron? Representative Herron?
Yes.
Representative Hodgson? Representative Huff?
Yes.
Representative Imes?
Yes.
Representative Johnson?
Yes.
Representative Maddox?
Yes.
Representative Rawlings?
Yes.
Representative Tate? Yes. Representative Tipton?
Yes.
Representative Williams?
Yes.
Representative Witten?
Yes.
Representative Hale?
Yes. Representative Bratcher, I apologize. I didn't see your question. We've already voted and
No, it's I'd like to record a yes
okay.
vote for
wait,
House.
Wait just a second. Let me finish
Okay.
this one, please. House Bill 138 passes with 19 favorable votes, 0 votes against. Should pass the same on the House floor. Thank you, Representative Grossberg, for being with us. Congratulations.
Thank you, Mr.
today.
Chairman, and thank you personally for your assistance bringing this before the committee.
Anyone else need to record votes? We will go first to Representative Bratcher. I'm sorry, Representative
House
Bratcher.
Bill 661. I'd like to record a yes, please.
And Representative Whitten.
Thank you, Chairman. House Bill 509, I need to record a yes, please.
Duly noted. Seeing no further business, we are adjourned.